Defending a DUI case can involve several different motions. One of those motions is a search and seizure motion. That motion is filed by defense attorney to challenge a stop or the blood test taken to prove a DUI case. The police officer has to have a reason to pull somebody over, or has to have an exception to the search and seizure requirement found typically in the United States Constitution. Generally speaking, an officer has to observe a vehicle code violation that he could cite a person for that involves speeding, running through a red light, or any other vehicle code violation, equipment, or weaving, for example. If you are arrested after being stopped for weaving or failing to show a blinker, please contact an attorney. There are recent case law which indicates that a police officer observation of a single weaving outside of a lane could be not sufficient basis to pull you over. If that's the case, the entire DUI prosecution may fall apart, resulting in a dismissal of your DUI case. Other than a good reason to stop you, an officer needs to have consent, a valid consent, to receive a sample of your breath or blood, or a warrant to draw your blood. Without a warrant or consent, the results of a blood test could be invalid. And typically, in all DUI prosecutions, blood test is a major evidence of impairment, and without a blood test, many DUI prosecutions will fall apart. If you did not give consent, or if your consent was coerced, forced by the police officer, or you were convinced to give a blood test without really wanting to do so, your case could be fought through a search and seizure motion, and the results of a blood test could be thrown out, also resulting in a dismissal. Please contact an attorney if you have one of those scenarios. Your case could be won.